The tension in the federal courthouse was palpable as Judge William Roberts leaned forward from the bench, his expression hardening with each word. The high-profile voting rights case had already drawn national attention, but no one anticipated how dramatically the power dynamic was about to shift. "Counselor," Judge Roberts began, his voice carrying that distinctive blend of Southern formality and judicial authority that had made him one of the most formidable judges in the Fifth Circuit. "Before you continue with this line of argument, I must express my profound concern about your characterization of these voting regulations." The courtroom fell silent as all eyes turned to Congresswoman Jasmine Crockett, who stood calmly at the plaintiff's table. Her appearance as lead counsel in this case, challenging a controversial state voting law, had already made headlines. A sitting member of Congress rarely argues cases personally, and Crockett's background as a civil rights attorney before her election added additional significance to her representation. "You've repeatedly asserted that these provisions create unconstitutional barriers to the franchise," Judge Roberts continued, his tone growing increasingly critical. "Yet the Supreme Court has clearly established that states have broad authority to regulate election procedures. Your characterization demonstrates either a fundamental misunderstanding of established precedent or a deliberate attempt to mislead this court." Murmurs spread through the packed gallery as observers registered the unusual directness of Roberts' attack. While the judge was known for his conservative jurisprudence and skepticism toward voting rights claims, he rarely confronted attorneys with such pointed accusations of legal incompetence during oral arguments. "What's particularly troubling," Roberts added, removing his glasses for emphasis, "is that someone with your congressional position would advance such questionable legal theories in my courtroom. The separation of powers requires that legislators respect judicial determinations rather than attempting to circumvent them through creative litigation." The attack was extraordinary. A federal judge publicly questioning both the legal competence and institutional propriety of a sitting Congresswoman appearing as counsel. The gallery fell completely silent as the implications registered. Roberts had essentially accused Crockett of either incompetence or improper motivation, a devastating charge against any attorney, but particularly one who was also an elected representative. Several other attorneys at the plaintiff's table shifted uncomfortably, clearly concerned about the judge's unprecedented hostility toward their lead counsel. Court observers recognized immediately that Roberts' comments had created an extraordinary moment in the proceedings, one that would require an equally extraordinary response. What happened next would stun everyone in the courtroom and soon captivate legal experts nationwide. Rather than responding with defensive justifications or deferential retreat in the face of judicial criticism, Congresswoman Crockett implemented a courtroom strategy so precisely calibrated, so deeply rooted in constitutional jurisprudence, and so unexpectedly authoritative that it would not only neutralize Roberts' attack, but fundamentally reshape the entire trajectory of the case. If you want to see exactly how Congresswoman Crockett transformed this judicial attack into one of the most remarkable moments in recent legal history, make sure to like this video and subscribe to our channel right now. Hit that notification bell so you never miss these extraordinary confrontations where preparation meets provocation and creates unforgettable moments of legal clarity. Now, let's dive into how this remarkable exchange unfolded and why Crockett's strategy left even veteran courtroom observers speechless. William Roberts, had built his reputation as one of the judiciary's most consistent conservatives during his 15 years on the federal bench. Appointed to the U.S. District Court by President Bush and later elevated to the Fifth Circuit Court of Appeals, Roberts had established himself as a formidable legal mind with a strict textualist approach to constitutional interpretation and a skeptical view of expansive voting rights claims. His judicial philosophy emphasized state authority over election procedures and required plaintiffs to clear extremely high bars for proving discriminatory intent rather than merely demonstrating disparate impacts. This approach had made Roberts particularly influential in shaping election law jurisprudence across the conservative-leaning Fifth Circuit, with his opinions frequently cited by like-minded judges in other jurisdictions. Roberts approaches voting rights cases with extraordinary skepticism. One legal scholar had observed in a profile published in the Yale Law Journal. He requires plaintiffs to produce a level of evidence demonstrating discriminatory intent that's practically impossible to meet in modern contexts where explicit racial animus is rarely documented. This jurisprudential approach had clearly informed Roberts' unusually hostile reaction to Crockett's voting rights arguments. From his perspective, her claims represented exactly the kind of expansive approach to the Voting Rights Act and constitutional equal protection that he had spent his judicial career opposing, one that he viewed as inappropriately intruding on state authority over election administration. Across the courtroom stood Jasmine Crockett, whose path to arguing this case reflected a very different constitutional vision. Before winning election to Congress, Crockett had established herself as a civil rights attorney, specializing in voting rights, litigation, challenging restrictions that disproportionately affected minority communities. Her legal approach emphasized the practical impacts of election regulations and their effects on different demographic groups, precisely the kind of results-oriented jurisprudence that Roberts had long rejected. She approaches these cases from the perspective of how voting systems actually function for different communities. A former legal colleague had explained to the Texas Tribune. When she interprets constitutional provisions or statutes like the Voting Rights Act, she's drawing on direct experience, seeing how abstract principles translate into concrete voting access for communities that have historically faced barriers at the ballot box. This perspective had informed the legal challenge that had provoked Roberts' unusual hostility. Crockett had advanced an interpretation of the Voting Rights Act that emphasized its protection of equal electoral opportunity rather than focusing narrowly on explicit discrimination, an approach that reflected her view that voting rights must be understood in terms of their practical operation rather than just their abstract formulation. The stakes of this confrontation extended far beyond the personal dynamic between Roberts and Crockett. The case challenged a state law requiring specific forms of government-issued photo identification to vote, while eliminating accommodations for voters facing documented difficulties obtaining such identification. Civil rights organizations had presented evidence that these provisions created disparate burdens on minority, elderly, and low-income voters, evidence the state dismissed as irrelevant without proof of discriminatory intent. The court's decision would potentially reshape voting rights jurisprudence across the circuit, determining whether the Voting Rights Act and constitutional equal protection principles required consideration of disparate impacts or merely prohibited explicit discrimination. With several states having enacted similar voting restrictions, the ruling would affect election administration for millions of voters and potentially determine whether significant communities would face new barriers to casting ballots. For Roberts, the case represented an opportunity to further cement his restrictive approach to voting rights claims and potentially limit the scope of the Voting Rights Act's results test that prohibited voting practices with discriminatory impacts regardless of intent. For Crockett, it offered a chance to defend a more functional interpretation that considered how voting restrictions affected different communities in practice, a perspective informed by her direct experience representing affected voters before entering Congress. The packed courtroom reflected these high stakes. Civil rights leaders sat alongside state officials in the public gallery, while law clerks and legal reporters filled every available seat. Supreme Court specialists leaned forward in anticipation, recognizing that Roberts' unprecedented attack had created a moment of extraordinary tension that would require an equally remarkable response. What none of them yet realized was that Crockett had anticipated the possibility of judicial hostility and had prepared a courtroom strategy specifically designed for this scenario, not a defensive retreat, but a sophisticated pivot that would draw on Roberts' own judicial philosophy and Supreme Court precedent to transform what appeared to be a losing position into an unexpectedly powerful constitutional argument. "Thank you for expressing those concerns, Your Honor," Crockett began, her voice reflecting neither defensiveness nor intimidation, but the measured confidence of an experienced litigator. "With the court's permission, I'd like to address them directly by clarifying both the legal basis for our claims and the specific precedents that inform our arguments." This opening tone immediately shifted the dynamic. Rather than responding with defensive justification or deferential retreat, Crockett had signaled her intention to engage substantively with the judge's criticisms, an approach that commanded attention precisely because it departed from the expected reaction to such judicial hostility. "Your Honor correctly notes that states have authority to regulate election procedures," Crockett continued, "and we're not challenging that fundamental principle. Our argument is more specific, that when such regulations impose demonstrably greater burdens on certain communities, they trigger scrutiny under both the 14th Amendment and Section 2 of the Voting Rights Act." She turned to a specific case binder, projecting both preparation and precision. In Crawford v. Marion County Election Board, which upheld Indiana's voter ID requirement, the controlling opinion by Justice Stevens specifically noted that the court's decision did not foreclose the possibility that such requirements could be unconstitutional if they imposed excessively burdensome requirements on particular voters. This strategic citation, beginning with a Supreme Court decision that had upheld voter ID requirements, was masterful. Rather than starting with cases favorable to her position, Crockett had directly addressed the precedent most likely in Roberts' mind, demonstrating sophisticated understanding of its actual holdings rather than the oversimplified version often cited by voting restriction defenders. Justice Stevens emphasized that the Indiana law included provisions accommodating voters who faced difficulties obtaining identification, Crockett noted. By contrast, the statute we're challenging today explicitly eliminated similar accommodations that existed in previous versions of the state's identification requirements. This precise distinction between a law the Supreme Court had upheld and the specific statute being challenged began shifting the conversation from abstract principles to concrete statutory details. Several law clerks could be seen taking notes, apparently recognizing the significance of this specific comparison that Roberts' characterization had overlooked. Moreover, Crockett continued, our challenge isn't based on abstract theories, but on the extensive factual record developed during discovery, which documented specific burdens these provisions impose on identifiable communities. She gestured toward the evidence binders. The statistical disparities in access aren't marginal or speculative, but reflect a 23-point gap in the ability to comply with the new requirements when comparing elderly minority voters to the general population, a disparity that persists even when controlling for income, education, and geographic location. This pivot towards specific evidence rather than general legal principles continued to command attention throughout the courtroom. Rather than allowing the argument to remain at the level of judicial philosophy, where Roberts clearly felt most comfortable, Crockett was systematically directing attention to the factual record that would be reviewed on appeal, creating a strategic focus on the elements most likely to survive the judge's skepticism. Regarding Your Honour's concern about respecting judicial determinations, Crockett said, addressing Roberts' suggestion of institutional impropriety, I must respectfully clarify that our arguments are directly grounded in the Supreme Court's own framework for analysing these claims. She turned to another case binder. In Brnovich versus Democratic National Committee, Justice Alito's majority opinion specifically identified 5 factors courts should consider when evaluating voting regulations under Section 2, including the size of the burden imposed by a challenged voting rule, and the differences in employment, wealth, and education that might make that burden more significant for certain groups. This citation of a conservative majority opinion, authored by Justice Alito, widely considered among the court's most conservative members, reflected another strategic masterpiece. Rather than citing more liberal voting rights precedents that Roberts might view skeptically, Crockett had grounded her argument in the jurisprudence of the court's conservative wing, demonstrating that even under the most restrictive modern precedents, the factual record in this case justified judicial scrutiny. Our presentation of statistical disparities isn't an attempt to circumvent precedent, but a direct response to the analytical framework the Supreme Court itself has established for these cases, Crockett explained. We're not asking this court to apply a novel legal theory, but to follow the exact multi-factor analysis that Justice Alito articulated for evaluating whether voting regulations violate Section 2's protection against discriminatory results. The courtroom had grown remarkably quiet as Crockett systematically reframed the entire case within the very jurisprudential approach that Roberts himself typically championed: strict adherence to Supreme Court precedent with particular attention to opinions from the court's conservative members. This strategic pivot had transformed what initially appeared to be a vulnerable legal position into an argument that drew strength from the very authorities Roberts most respected. Counselor, Judge Roberts interjected, his tone still skeptical but lacking the dismissive edge of his initial comments. Even accepting that framework, Brnovich emphasized that disparate impact alone is insufficient to establish a Section 2 violation without a showing that the challenged regulation creates a substantial obstacle to voting. It was precisely the judicial response Crockett had anticipated and prepared for extensively. Your Honour's characterization of Brnovich is exactly correct, she responded without hesitation. That's why our evidence goes well beyond statistical disparities to document specific individuals who face substantial obstacles under these provisions. She turned to another section of the evidence binder. The record includes sworn testimony from 47 eligible voters who have been unable to vote under the new requirements despite multiple attempts to comply. These aren't hypothetical scenarios, but documented cases where qualified citizens faced precisely the kind of substantial obstacles that Justice Alito identified as potentially violating Section 2. This direct engagement with Roberts' specific concern, addressing his characterization of precedent as accurate, while demonstrating how the evidence satisfied even his restrictive reading, continued to shift the courtroom dynamic. Legal observers exchanged impressed glances, recognizing that Crockett was systematically transforming judicial skepticism into a framework for presenting her strongest evidence. For example, Crockett continued, plaintiff Maria Vasquez made 7 separate attempts to obtain compliant identification, including traveling 94 miles to the nearest state office that issues such ID. Despite bringing her birth certificate, social security card, and utility bills, she was rejected because her married name differed from her birth certificate, a circumstance that disproportionately affects women, and particularly women of color in this jurisdiction. The specificity of this example, connecting abstract legal standards to concrete human impacts, visibly affected several clerks, and even appeared to give Roberts momentary pause. By presenting precise factual examples rather than general legal theories, Crockett was making it increasingly difficult to dismiss the plaintiff's claims through abstract legal doctrine alone. Your Honor, Crockett said, pivoting to yet another strategic dimension. I'd like to address directly why appearing as both a member of Congress and an attorney in this case is not just appropriate but consistent with the highest traditions of our profession and constitutional system. This proactive addressing of Roberts' suggestion of institutional impropriety represented another element of Crockett's carefully calibrated strategy, confronting potential vulnerabilities directly rather than hoping the judge wouldn't return to them. Members of Congress have a long history of maintaining legal practices while serving in office, she noted. Representative John Lewis, for example, frequently participated in voting rights litigation while serving in Congress, drawing on his unique expertise in these issues, just as I am doing today. This reference to Lewis, a civil rights icon widely respected across ideological lines, was another strategic choice that made it more difficult for Roberts to maintain his suggestion of impropriety without implicitly criticizing a revered figure in American legal history. More fundamentally, Crockett continued, our constitutional system benefits when courts have access to diverse perspectives informed by different institutional experiences. My background both litigating these cases and participating in legislative attempts to address voting barriers provides context that may assist the court in understanding the full dimensions of these issues. She paused briefly. Of course, I recognize that my congressional role is entirely irrelevant to the legal merits of this case, which must stand or fall based on the evidence and applicable law. That's precisely why our presentation has focused exclusively on the factual record and Supreme Court precedent rather than legislative considerations. This careful distinction, acknowledging that her congressional position created no special legal authority while defending its propriety, further neutralized Roberts' suggestion of institutional overreach. Several attorneys in the gallery nodded slightly, recognizing the effectiveness of this approach in addressing a concern that could otherwise have undermined her credibility with the court. "If I may return to the legal merits," Crockett said, smoothly transitioning back to the case's substantive core, "I'd like to address how the evidence in this case satisfies even the most stringent reading of the Brnovich factors." She proceeded to systematically connect each element of the factual record to the specific analytical framework the Supreme Court had established for Section 2 claims, demonstrating how the documented disparities, specific obstacles, and historical context all aligned with the exact legal standard Roberts himself had referenced. As this methodical presentation continued, the courtroom dynamic had transformed completely from the hostile atmosphere following Roberts' initial attack. What had begun as judicial skepticism bordering on hostility had evolved into increasingly engaged questioning about specific evidentiary points and their relationship to controlling precedent, precisely the substantive legal exchange that Crockett's strategy had been designed to create. Even Roberts himself appeared to be recalibrating his approach, his questions becoming more focused on particular aspects of the evidence rather than broad dismissals of the legal theory. While his skepticism remained evident, the tone had shifted from dismissive hostility to substantive engagement, a transformation that veteran court observers recognized as potentially significant for the case's ultimate resolution. "In conclusion, Your Honor," Crockett said, as she prepared to return to her specific legal arguments, "we're not asking this court to depart from Supreme Court precedent, but to apply it faithfully to the extensive factual record before you. That record demonstrates exactly the kind of substantial obstacles to voting that even the court's most restrictive interpretations of the Voting Rights Act have recognized as potentially unlawful." The courtroom remained completely silent as Crockett concluded this strategic repositioning of the entire case. What had begun as a judge's attempt to dismiss her arguments as legally unsound had been transformed through her response into a substantive engagement with precedent and evidence that had fundamentally altered the trajectory of the proceedings. The impact of Congresswoman Crockett's extraordinary courtroom strategy in response to Judge Roberts' attack was immediate and far-reaching. As the hearing concluded, legal experts who had witnessed the exchange emerged from the courthouse to find news crews waiting for their analysis of what many were already describing as a masterclass in appellate advocacy. What we witnessed wasn't just effective response to judicial skepticism, but a complete transformation of the case's framing, noted constitutional scholar Lawrence Tribe. Representative Crockett didn't just defend her position, she systematically repositioned the entire legal argument within the very framework of conservative jurisprudence that Judge Roberts himself champions. That strategic pivot could prove decisive not just for this case, but for how voting rights claims are framed going forward. Legal reporters filed stories highlighting the unprecedented nature of both Roberts' direct attack and Crockett's strategic response. Headlines like "Crockett turns judicial skepticism into legal opening" and "How a Congresswoman's Courtroom Strategy Reshaped a Landmark Voting Rights Case" captured the extraordinary significance of the moment for readers who hadn't witnessed it directly. Legal blogs and constitutional commentary sites filled with detailed analyses of the exchange, with particular focus on how Crockett had engaged directly with conservative jurisprudence, rather than simply citing more liberal voting rights precedents. This approach, meeting skeptical judges on their own judicial terrain rather than appealing to principles they already rejected, had dramatically altered the dynamics not just of the hearing, but potentially of voting rights litigation strategy more broadly. By grounding her arguments in Justice Alito's Brnovich framework rather than more expansive voting rights precedents, Crockett presented a theory that even conservative judges must seriously engage with, explained election law expert Richard Hazen. She didn't ask the court to adopt a novel interpretation, but to apply existing conservative jurisprudence to the specific factual record developed in this case, a framing that makes the plaintiff's claims much harder to dismiss through traditional doctrinal objections. For Crockett herself, the aftermath brought both increased prominence and enhanced credibility as a constitutional litigator. Legal organizations across the ideological spectrum invited her to speak about effective appellate advocacy, recognizing that her response to Roberts had demonstrated a sophisticated understanding of how to navigate hostile judicial terrain rather than a narrowly partisan approach. What distinguished the Congresswoman's strategy, noted conservative legal scholar Orrin Kerr, was her engagement with the court's legitimate concerns rather than dismissing them. By acknowledging the force of precedents like Crawford and Brnovich, while demonstrating how the evidence satisfied even their restrictive standards, she created space for meaningful judicial consideration regardless of ideological perspective. Law schools incorporated audio of the exchange into appellate advocacy courses, with professors using it to demonstrate how effective advocacy requires understanding and engaging with skeptical judicial perspectives, rather than simply advancing arguments that align with a particular ideological approach to the underlying issues. The exchange exemplifies what we try to teach our students about appellate strategy, explained Yale law professor Akhil Amar. Rather than treating different jurisprudential approaches as fundamentally incompatible, Representative Crockett showed how voting rights claims can be articulated through multiple constitutional frameworks, making her arguments accessible to judges across the ideological spectrum. Perhaps most significantly, the exchange influenced subsequent voting rights litigation beyond the specific case. Legal teams, challenging similar restrictions in other jurisdictions, began adopting Crockett's strategy of grounding their claims in conservative voting rights jurisprudence while presenting extensive factual evidence of specific burdens rather than relying primarily on statistical disparities or broader theories about discriminatory intent. The Crockett approach demonstrates why voting rights litigation requires attention to both judicial philosophy and empirical realities, observed election law professor Daniel Tokaji. When advocates frame their claims to engage meaningfully with the jurisprudential concerns of skeptical judges, while presenting compelling factual evidence about specific burdens, they create space for successful challenges even in courts generally unsympathetic to expansive voting rights interpretations. When the Fifth Circuit ultimately issued its decision 4 months later, the impact of Crockett's strategic approach became even more apparent. While the court upheld portions of the challenged law, it struck down key provisions based on the specific evidence of substantial burdens facing particular communities, explicitly citing the testimony and statistical evidence that Crockett had highlighted in direct response to Roberts' initial skepticism. Most remarkably, Judge Roberts himself wrote a concurring opinion acknowledging that, while he maintained his restrictive approach to voting rights, claims generally, the specific factual record in this case demonstrated the kind of substantial obstacles to voting that cannot be justified by legitimate state interests in election integrity, a striking evolution from his initially dismissive reaction to the plaintiff's claims. The concurrence represents an extraordinary moment in voting rights jurisprudence, noted Supreme Court reporter Linda Greenhouse. Without abandoning his generally skeptical approach to these claims, Judge Roberts acknowledged that the specific evidence presented met even his restrictive standard for establishing a violation, demonstrating how Crockett's strategic engagement with his jurisprudential framework created space for this evolution. For voting rights advocates nationwide, the case established a new template for challenging restrictions even in conservative jurisdictions, focusing intensively on developing specific factual records about individual voters facing substantial burdens, rather than relying primarily on broader theories about discriminatory purpose or generalized disparate impacts. The successful approach reflects precisely the strategic pivot that Representative Crockett implemented in response to Judge Roberts' initial hostility, explained voting rights attorney Sherilyn Eiffel. By connecting abstract legal standards to concrete human impacts while engaging directly with conservative jurisprudence, advocates can create more effective challenges even in courts generally skeptical of voting rights claims. As for the exchange itself, it had become required listening for law students preparing for appellate advocacy, a model for attorneys facing hostile judges, and a powerful reminder that even the most challenging moments in oral argument can become opportunities for strategic repositioning when met with the right combination of preparation, perspective, and strategic discipline. In transforming Roberts' unprecedented attack into an opportunity to reframe the entire case within conservative voting rights jurisprudence, Crockett had not only advanced her client's cause, but potentially reshaped voting rights advocacy for a generation, demonstrating the remarkable power of strategic legal argument to transcend ideological divisions and create space for constitutional protection even in the most challenging judicial environments. If you found this breakdown of the Roberts-Crockett exchange informative, please hit that like button and subscribe to our channel for more in-depth analysis of consequential legal confrontations. Click the notification bell to make sure you never miss our coverage of the cases that reshape constitutional understanding and legal strategy across ideological lines. Your support helps us continue bringing you detailed analysis of how our legal system evolves through the interaction of prepared advocates and engaged judges across the jurisprudential spectrum.